Things have changed for the 3-day notices for the state of California, and we are going to run through the different 3-day notices that a landlord can deliver to a tenant. That's the 3-day notice to pay or quit, 3-day notice to cure or quit, and the 3-day notice to quit. We're going to run through, show you some sample forms and exactly when these would be used. Plus, stick around to the end because we're going to cover two important things. One is how to serve the form, and two is where to get the form. Hey there, Christian Walsh, real estate agent with Wire Associates. We have been helping tenants and landlords make sense of these crazy days, and we're here with a big update on the 3-day notice. These have changed dramatically through the eviction moratoria, through COVID. We've had at least 3 different notices to pay or quit. Those days are over in most areas, so now it's time to use these forms. A few important points before we dive in. The forms we're going to discuss are for at-fault termination of tenancy, and that means the tenant has done something wrong. It is not for no-fault termination of tenancy, where the landlord is terminating the tenancy and the tenant hasn't done something wrong. We've done other videos on no-fault termination. That would be a 30, 60, or 90-day notice. Make sure you check out that content. Another important point is there still are some local eviction moratoria in place throughout the state of California. You need to know before delivering these forms. In fact, you may not even be able to deliver these forms if there's a local eviction moratorium in place. That's where you're going to turn to an attorney. And speaking of attorneys, we cannot give tax or legal advice, so we recommend you find the appropriate professional. But for the most honest and up-to-date real estate advice, you can subscribe to this channel. The other important point, this is a guide for tenants and landlords. While it may sound like we're just telling landlords how to give the notices, tenants, you need to understand how these forms work to know if you've been given the form correctly. So this is a message for both renters and landlords to hear. So if you're ready to dive into notice to pay or quit, notice to cure or quit, and the notice to quit, hit that like button. And let's get started. Let's dive into the notices. We'll start with one of the most popular ones, which is the 3-day notice to pay rent or quit. And this is brand new. We're looking at a cover page for this notice. And don't forget, you don't have to use the ones from the California Association of Realtors that I'm running through. The cover letter essentially says that this is going to be delivered after July 1st, 2022. In particular, the notice to pay rent or quit, there were several different versions, and depending on which rent you're asking for, there still are several different versions. This will be the one you use for any rent that's due October 1st, 2021 or later. You're going to go ahead and use this. If it's before then, if it's September 1st, 2020 through September 30th, 2021, you're going to need to go a different route, talk to an attorney. And if you're collecting any rent that's over a year old, if that's going to be referenced on the form, talk to an attorney. And there's a CARES Act warning as well. Go ahead and take a look here. If you're subject to Section 8 or any voucher programs, or there's a loan against it that's FHA, VA, Fannie Mae, or Freddie Mac, there may need to be a 30-day notice. This has expired, but you're going to talk to an attorney about it. So you're not going to include this page. You're going to include this. So here's the notice to pay or quit. You're going to go ahead and fill out the top. It's the obvious stuff. It's the rental unit and who it goes to. You're going to want to reference all the tenants that are on the lease. The notice is going to go ahead and it's going to outline the rent that's past due. If you have more rent than you can fit on these lines, you're going to go ahead and use an additional page so that you can cover the rent. Again, remember, if it's before October 1st, 2021, you're not going to want to include it on here. And if it's over a year old, you're not going to want to include it on here. So talk to your attorney about those specific situations. You're going to tell the tenant where the rent can be delivered, to whom, phone number, when, where, so that they actually have a legitimate chance to deliver the past due rent once they've been served this form. And Section 3 covers what happens in the event that the tenant does not pay that back rent that's owed or surrender possession. And essentially what happens next is the unlawful detainer action. That's where the eviction goes into the court system to be taken care of. And again, we recommend an attorney helping with that. So the delivery of notice / proof of service, we're going to cover that at the end of this video. Vitally important that this notice is delivered correctly. And the next at-fault notice, and this is the notice to cure or perform covenant or quit. So this is where the tenant has done something wrong and they have a chance to rectify it. Has the same cover page as the last notice. It is very similar to the last notice in some respects, but it references the Tenant Protection Act, and we've done other content on AB 1482. Landlords need to know whether their property is subject to AB 1482 or not. And there's a strange way of using this form, and this is unique to the California Association of Realtors form. So you're going to fill out paragraph 2 or 3 as the landlord, and we're going to run through quickly some of the things that this covers. But here's what's interesting is you don't check the box for the paragraph that you're using. So you see a box here above 2 and a box here above 3. You actually check the box for the one that you're not using. So this is an interesting thing. So you only check one box, and it's the one that you're not using. So make sure you do that right, because it's a little bit backwards to me. You'd think you'd check the box you're supposed to be using. So this runs through within 3 days, excluding Saturdays, Sundays, or other judicial holidays, and that's important to know. That's the 3-day notice. Same thing for the non-payment of rent. So this form, you're going to figure out whether your property is subject to the Tenant Protection Act or not, and then you're going to fill out the required section. So this is properties subject to the Tenant Protection Act. Watch our other video if you need help on figuring that out. And it runs through things that can be cured. Let's start at 3. It shows money. This is a monetary obligation other than rent. So for example, if there's utilities that a tenant is supposed to pay a landlord and hasn't paid those would go on this form, not necessarily on the notice to pay rent. The other thing here is that if a tenant didn't sign an extension or renewal of lease, provided that it's similar to their previous lease, then they potentially can have their tenancy terminated. And then the other big one that a lot of tenants don't seem to realize is if the tenant is given proper legal notice for a landlord to enter, and they do not allow the landlord to enter, they can be given a 3-day notice for that. And that's what number 2 references. Here's where the rubber meets the road on it, and the difference between the Tenant Protection Act covered properties and those that are exempt. It's right here. If the property is subject to the Tenant Protection Act, then the tenant will receive, after this notice, a 3-day notice to quit. So that's the difference if the property is subject to the Tenant Protection Act. If it isn't, that additional 3-day notice to quit, which we're going to cover in a minute, is not required. So just so you know what the difference is between these two sections. Again, the box checking is backwards. So if the property is not subject to the Tenant Protection Act, at the bottom here, it says under B that you would essentially immediately move to unlawful detainer. There would not be that additional 3-day notice to quit. See how confusing all this is? This is why you need an attorney, to make sure that you're giving the correct paperwork and make sure that the reason that you're giving the paperwork is a valid and correct reason. And this is the 3-day notice to quit, and there's certain reasons where a tenant would not have the ability to cure anything, would not have the ability to pay back rent or cure certain things. They simply have to give up possession. That's when you use this form. And also, if the property is subject to the Tenant Protection Act and they've been given the 3-day notice to cure and they didn't cure, they need to get this. So again, get an attorney involved. So let's run through the 3-day notice to quit very quickly. It runs through a list of when it would apply. So we can see a violation of the lease against subletting, assignment, or committing waste under A. That would be an example of where the tenant would get the 3-day notice to quit. Now, what's important is I referenced a local eviction moratorium. For example, in Los Angeles right now, you can't actually terminate a tenancy for having additional people in there or for having pets in the property. You cannot have the notice to quit given because of the eviction moratorium. So that's again why an attorney is important. So B is maintaining a nuisance. A nuisance has a legal definition. Talk to an attorney to make sure that what the tenant is doing meets that. Using the premises for an unlawful purpose or a criminal threat. A former owner holding over after the sale of the premises. Don't mistake D for a tenant staying in possession. This would be the former owner. So the owner didn't move out after the property closed. That's when we use D. And then E is related to an on-site property manager, for example, that stays on after they've had their employment terminated. They can be evicted. Then F, you can see this references the previous form, the cure or quit form, and they didn't cure or quit. So this goes ahead and is used in conjunction with that form, and you can check one of these boxes. And don't forget, as it says, if there's a local rent or eviction control jurisdiction, a different notice may be required, or you may not even be able to give the notice. So that is the notice to quit. Thanks for sticking around to the end. This is a very important topic that you need to know, and that is proper serving of the notice. It's just as important as giving the notice or the correct notice. You have to make sure that it's properly served or it will be invalid. You'll find this receipt, essentially is the way to look at it, on all three of the notices we've just gone through from the California Association of Realtors. You can hire a process server. So if you Google up process server, like my son likes to say, Google it up. If you Google up process server, you will find one in your local area or wherever the property may be, and the process server will make sure that it's correctly served. I recommend doing that because this is, if done wrong, going to set you back some significant amount of time, potentially. If you get all the way through the unlawful detainer, get in front of the judge, and the judge says it wasn't properly delivered, you start over. So the process server can make sure it's done right. You can do it yourself, or you can have an agent or friend do it. This is the preferred order. So number one would be personal service. And that means that a copy of the notice is handed to one of the tenants referenced on the lease. So that's the best way to do it. And ideally, the process server is going to do that. The next one below personal service is substituted service. So this would be another adult that's in the house, for example, not referenced on the lease, but they're 18 or over. You can give the notice to that person, and that would be considered substituted service. C would be the least preferred, but still the legal route to do, and that would be to post and mail. So post would be, you could use a nail and pound it in the door, but that's your door. Why would you do that? We typically will use a plastic bag, hang it from the doorknob in an envelope, and then we'll take a picture showing that we've done that, and then we will send it via mail. Now, technically, first-class mail is sufficient. I think it's best to send via priority mail. The advantage with priority mail, not certified, but priority mail is going to give you a tracking number, and they do not have to sign for it. Now, we just ran into a situation where a landlord asked us what to do in this case. In this case, what happened, he went to personally serve the notice and told the tenant he was there to serve the notice. The tenant said, no, I'm not going to take it, and shut the door. So what do you do in that case? Well, you're going to go ahead and take notes. He actually had video of that, so that's good. You have video. But then in that case, I would post and mail it. So the door's shut in your face, just post it to the door, mail it via priority mail, and you're covered. Plus you have the video showing you tried to personally serve it. Once you've done that, you're going to come back and you're going to go ahead and mark on this form what you did and keep a copy. Now, obviously, when you're handing it over, you're not going to be able to necessarily mark it. So you're going to mark your copy and keep it for your records. In the event that you move forward the unlawful detainer, you will have records, and you may need to show up personally or have an affidavit from your process server or have your friend or agent show up to prove and discuss that they served it. So make sure you send the proper notice and make sure it's delivered properly. And again, if I've mentioned this a few times, hire an attorney to make sure it's done right. And of course, one of the most common questions we get is, where can we get these forms? So there's a few different places. If you want to get the California Association of Realtor forms, you can ask your local realtor, whoever you work with, to give you a copy. I still encourage you to hire an attorney. And if you do hire an attorney, they are going to have forms that you can use. The last place that you can turn would be to a local apartment or landlord association. For example, there's the CAA. I'll have a link below. I'm in Orange County. There's the AAOC. There is most likely either a city or county apartment association that you can turn everywhere in California. They will have copies of the forms as well. And while we can't give tax or legal advice, if you hire us as an agent, we can help you with these forms as long as it doesn't turn out to be tax or legal advice. Leave your questions below. I'm sure there's going to be some out there, and we'll do our best to answer or point you in the right direction. Make sure you subscribe to our free weekly email newsletter so that you know about forms and laws and regulations that are coming for tenants and landlords throughout California and beyond. And check out this next video where we cover topics that you don't want to miss as a California landlord or California tenant. Thanks for tuning in. This has been Christian Walsh, real estate agent with Wire Associates, and we want to hear from you.